Hi everyone, thank you for tuning in today. My name is Brian Pufolks with Pufolks Law Firm.
And my name is Parham Zahedi, an associate at Pufolks Law Firm.
As you can see, we're doing things a little bit differently today. Today we're going to discuss a very important and significant victory, and the reason we're going to talk about this case is because we believe it has very important lessons for our audience. Where we just learned in the mail that we had an approval on an I-360 FAWA case, and we'll discuss a little bit more in detail what that means. So before we get started, just a couple quick things. The client that we're going to refer to preserve his confidentiality, we're going to refer to him as Simon. And I'll give a little background on this case so you have a little bit of understanding and context as we get into the details. About 1 year ago, almost exactly 1 year ago today, Parham and I were having lunch, and I received a phone call from a friend. And this friend told me she had a friend whose husband was recently detained. A little bit of background on Simon. Simon was detained, and he had a lot of problems in his immigration history, which caused him to be detained. He came into the United States through the southern border illegally a number of years ago. Shortly after living in the United States, he got married to a U.S. citizen, and they had a daughter together. The relationship had problems, and at some point, Simon was accused of having controlled substances in his vehicle, and he was arrested for that. But thankfully, those charges were dismissed. However, after he was arrested for controlled substances, he was put into deportation proceedings. He hired a lawyer, and unfortunately, that case ended up with a deportation order. That same lawyer who was representing him in deportation proceedings filed a motion to reopen. However, the judge denied the motion to reopen, and Simon never left. Sometime later, he met his now girlfriend and fiancée, and together they have 4 children. And Simon continued with his life, keeping very minimal relations with his estranged wife, except for the fact that every weekend or every other weekend he would see his daughter. So by the time I get this phone call during our lunch, he was picked up by ICE for being a fugitive, and ICE was looking to deport him as quickly as possible. Parham was the attorney who was assigned to this case, and many aspects of this case can be instructive for our audience. So I thought you can give a little bit of background on this case, touching on why it's important on A, who you hire as an attorney to represent you, and then also, is there anything that you can do after an attorney already messed up your case?
Right. So this case is a very good example of a very messed up case, as Brian called it. Client comes and you get the case in a very hopeless situation where the client has already had an order of deportation. On top of that, has already had a failed motion to reopen and has some dark history like allegation of controlled substance and child abuse in the case, and the client is just few days away from being deported from the country. So the question is what we should do and what can we do for the client. So the first thing that every attorney should do in these cases is to gather information. So we talked with Simon, and we found out that he had a very troubled marriage with his strange U.S. citizen wife. He was subject to repeated abuse, physically and mentally. He's always afraid of her to retaliate against him because he's not paying enough or he's not taking care of the wife, and a lot of other nonsense that the wife is forcing Simon to do. So that's a very good example of a good VAWA case. So why the first attorney did not even ask or think about doing VAWA for him?
And so his lawyer never brings up this defense, and that case results in a deportation order. And it's only years later where he retains our office to represent him while he's already in detention. How do you prevent him from being deported, and how do you get him out of detention?
So you have generally 2 options. You either can ask from the last court that decided your immigration matter, it can be Immigration Court or the Board of Immigration Appeal, BIA, to reopen your case and ask for a stay of removal from the court. We call it an emergency motion for a stay. That's your first option and kind of your best option to go with. The second option is to ask the ICE itself, the immigration police. We call it there is a motion that we call it motion 246, that you can ask them based on humanitarian reason, compelling humanitarian reason to stay the deportation for you. But there is no guarantee. However, if you can get the stay of deportation from the immigration court, then that's mandatory for the outside.
Okay.
So we figured out that this case is a great example of ineffective assistance of counsel. If Simon had a good lawyer and a competent lawyer who could identify the issues in his case and find the right relief for him, he could have become a green card holder, a legal permanent resident, long ago.
And one of the great things about an ineffective assistance of counsel defense is that you're not limited necessarily to a one motion rule. And you can also waive out the 30-day requirement to file your motion to reopen.
So as soon as we filed the motion, within 1 or 2 days, we heard back from the judge that the judge had a state deportation of Simon, which was a very good news for us. Then after 30 days, judge decided on our motion to reopen. And unfortunately, judge did not find our argument compelling enough to reopen Simon's case.
Okay, and just so the audience is clear, you filed a motion to reopen based on ineffective assistance of counsel, arguing that the result could have been different if he had a good lawyer, essentially.
Exactly, essentially.
Did we have to submit any applications for relief so that if the motion to reopen was granted, he would now have a pending application for relief?
Yes, of course, because you can't just ask the court to reopen your case based on ineffective assistance of counsel. So as soon as we got the case, we submitted a VAWA application for him to USCIS. When you have a VAWA case, not only you're eligible for the VAWA itself, but also you're eligible for one other relief called a special rule cancellation. One big advantage that a special rule cancellation provides for alien like Simon is that it automatically stay the deportation of alien until final appeal of the case.
Wow, that's huge. I just want the audience to understand the amount of work that gets involved in a very complicated case. From the time that we were hired, within 4 or 5 days, we filed an I-246 application to the Department of Homeland Security, asking them to exercise discretion on a humanitarian basis. We filed a motion to reopen to the immigration court, asking them to reopen the case and to also stay his deportation based on ineffective assistance of counsel, submitting a VAWA application to immigration, and also asking for relief based on special rule cancellation. And the law says that once a special rule cancellation application is pending, there is a statutory bar that prevents the Department of Homeland Security from deporting him, so their hands are tied.
Exactly.
So now Simon has some peace of mind knowing that he can't be deported, but he's still in detention, and we're still waiting for the immigration judge to rule on this pending motion to reopen. So what happens?
So what we did in this period that we were waiting for the immigration judge decision was to be constant communication with Simon's deportation officer, reminding them that we cannot deport him because there's a case pending.
Right, which is a great point, right? So there was a lot of communication with the ICE officer who may not understand that there's a statutory stay.
Exactly.
And it came in handy because at some point the immigration judge denied the motion to reopen, and therefore there no longer was a stay from the judge, but there was still a statutory stay because of that pending special rule cancellation motion.
Right. So if we didn't have the automatic statutory stay, Simon could be subject to immediate removal.
Just so we're clear for the audience, on what basis did the judge deny the motion to reopen?
The judge didn't really actually find our VAWA application approvable and called it dated, old, because it happened 12 years ago. We don't agree with the judge. It doesn't matter when you were subject of an abuse by a U.S. citizen spouse. You were subject to an abuse, and you can be eligible for VAWA application.
So the judge was wrong.
That's our belief, yes.
And I mean, and I'll give a closer view of this for the camera, but this is our decision. And clearly the USCIS granted this VAWA case. And so in other words, even though the judge discredited his case, after the government took a close look at it, they decided it was approvable.
Exactly.
Okay, so the judge denies the motion to reopen, but we have a stay. So how do we get him out of detention?
So if you think that your detention is unlawful because government is unable or unwilling to deport you, then you can go to federal court and file a petition that we call habeas corpus to ask from the federal judge for your release. So that's the thing we did for Simon in this case. And our reason was, we know that the government cannot deport Simon because he had a motion to reopen pending. Oh, by the way, when we received the immigration judge decision, he obviously appealed it to the BIA. So his case was still pending before BIA. And as we talked about, he was subject to statutory stay and removal. So it was obvious that government cannot deport Simon. Therefore, the question remained how long his case will be pending before courts for a final adjudication. Simon could win, Simon could lose. Only if Simon lost, the government could then deport him. But that could take years.
Yeah, and just so the audience is clear, you filed an appeal to the BIA. That appeal is still pending.
Yes.
So the courts are slow. So what's Simon's status now? Is he still in detention?
Well, thankfully no, because beside the habeas corpus, we were lucky because Simon was detained in New Jersey. So there is a specific law in New Jersey called Guerrero-Sanchez. It's actually a case law that says that every alien who is detained in detention for more than 180 days, 6 months, they can ask for a bond hearing before an immigration.
And what's so great about Guerrero-Sanchez is that in Guerrero-Sanchez bond hearings, it's the government who has the burden of showing that this person is a flight risk or a danger to society.
Exactly.
Okay, so what happened at the bond hearing?
Yeah, so we won the case in the bond hearing because we could show that Simon is a very good lad.
So that's huge. So he rejoins his fiancée and their 4 sons together. And now we have a motion to reopen pending in the Board of Immigration Appeals. And we had a VAWA case pending with USCIS. And what did we just learn?
Well, we just learned today that the VAWA case that the immigration judge called it dated and not approvable was just approved. So now what we can do is notify the BIA that this VAWA was approved. Therefore, immigration judge was wrong. Therefore, the case should be reopened.
So that's great news. So you feel very confident that we're going to get our motion to reopen approved. Is there anything else that we're doing or considering doing that can help Simon in his journey to become legal in the United States?
Yeah, definitely. So one other thing that we can do for Simon is to file for an application called 212. So basically, what this application does is to forgive the prior order of removal that Simon had in his case. So under normal circumstances, if you have an approved 212, you're required to leave the country, go for a consulate interview, and then come back in. However, Simon's case is different. His application is based on VAWA. And one exception that VAWA has for 212 is that you are no longer required to leave the country. Therefore, you can file your application concurrently at the same time as you file your 485, which is the adjustment of a status application.
The green card application.
The green card application.
Okay, so you're telling me that we have got him out of detention, we have a strong motion to reopen pending, and we also have this additional pathway now where we can file a 212 waiver and concurrently at the same time file a green card application, which he may win.
Exactly.
Well, this takes us to the end of the video. I really appreciate you, Parham, for just doing a magnificent job in helping Simon through his entire journey.
My pleasure.
But secondly, more importantly, I really want our viewers to understand how important it is to hire the right attorney and the big difference it can make in your life and the results of your case on who you hire. And just to think that taking an impossible case less than a year ago to being at a place now where someone is united with their family and has 2 strong, viable pathways to legal status in the United States, that's amazing. So please, if you enjoyed this video, please take a moment to like this video and to subscribe to this channel so you can be aware of all future content. Thank you for joining us today.
Thank you. Have a good day.